Good day, I'm Celeste de Haas from Remax Midlands, and this is part 2 of our 2-part video on buying deceased estate property. The question we had is, does a property sale agreement go ahead in the event of death? Well, buying or selling real estate isn't as easy as it's portrayed sometimes, especially if there's a death of a party in the transaction, which can make it challenging. Just because you enter into a contract to buy or sell does not mean the deal will go through. Agreements concluded prior to the death of either party to a sale agreement in circumstances where transfer has not yet taken place remain valid and enforceable. In the death of a party, however, cause inevitable delays, and in some instances it would no longer be practically possible to proceed with transfer. For example, where a purchaser has bought a property with mortgage finance from a bank, as the bank would probably withdraw the bond as there would be no longer be an income to support the payment of the bond. However, on a cash transaction, the estate would be obliged to proceed with transfer and pay the purchase price, or alternatively come to an agreement with the seller with the cancellation of the sale. We are going to make you aware of the delays of transfer in the property. In the event of the death of a seller, the power of attorney signed by the seller in favour of the conveyancers to effect transfer falls away, and the conveyancers now require the signature of the executor to execute power of transfer. This applies even when documents have been lodged at the deeds office and documents would have to be withdrawn from the deeds office in these circumstances. The power of attorney must also be endorsed by the power of the Master of the High Court, which can also cause delays. The Master can only endorse power of attorney once it has satisfied itself that all the requirements have been met and that there is no impediment to the transfer of the property. For example, where a estate is insolvent. What happens upon the sale of a property by an executor? 1. The executor can only sell and transfer the property with the consent of the heirs to the estate unless the property is sold to meet the debts. 2. The Master's office will likewise endorse the power of attorney to transfer the property, which will be submitted to the deeds office. And 3. The Master's office will only do so once it is satisfied that the heirs have consent to the sale of the property and provided that the proposed transfer is in accordance with the liquidation and distribution account which has lain for inspection with no objections. With reference to we have just mentioned, it is clear that care should be taken upon the sale and transfer of a property where a deceased estate is involved, and that parties to the sale agreement is made aware of the inevitable delays of complying with the Estates Act and the Deeds Registry Act. We also have available a step-by-step guide on reporting a deceased estate. So pop us a mail or a message, call us. We would love to hear from you. I am Dynamite Das.